Every young lawyer nervously awaits the day when his or her mettle is tested, and he or she must choose between what is in the best interest of the client and what is in the best interest of the lawyer. Most of us hope to have enough experience prior to that day to garner the appropriate response in such a heady situation. In criminal defense, the ethical quagmire of putting our clients before ourselves becomes especially murky, as our clients are, quite frankly, criminals. For intellectuals, philosophers, and political scientists, there is no dilemma in defending a criminal defendant. We do not defend their actions. We defend their constitutional rights. We are the protectors of the Fourth, Fifth, and Sixth Amendment rights of every citizen. Once our clients lose those rights, so do all honest Americans. The Machiavellian position of the prosecution, that overlooking the search and seizure rights of one person is justified in getting a conviction, is a paltry excuse for sloppy police work. However, just as a DA must tackle the ethical dilemma of entering illegally obtained evidence into court, a defense attorney must address how far they will go to protect their client. I did not expect that day to come for me before the ink had dried on my admission certificate. Merely 3 weeks after I was sworn into New York State Bar, I was given a small court appearance to cover alone. I needed only to get an adjournment of the matter so that a colleague could appear the next time. The client was a young woman in her 20s. She was suffering from bipolar disorder and had a compulsion for stalking her ex-boyfriends. She already was on probation for stalking one ex-boyfriend when she was rearrested for stalking a second. This time, the second ex was pressing charges. We were defending her on those charges. When I appeared in court that morning, her parents confessed that they did not believe she was really mentally ill and that they had been withholding her antipsychotic medication. They further informed me that they had told her a few things before court to calm her down. I didn't think much of it. Things went smoothly in court, and after we obtained our adjournment, I then exited the courtroom into the corridor with the client. The client inquired of me why there was an adjournment date if the charges were being dropped. Confused as to what she meant, I corrected her, indicating that the charges were not in fact being dismissed. She flew into a fit. It turned out that those few things her parents had told her to calm her down involved a lie in which the ex was dropping the charges. Distrustful of both me and her parents now, she whipped out her cell phone to call the ex-boyfriend to confirm that he was in fact dropping the charges. After all, lawyers are the ones that lie, not parents, right? If that call was completed, it was a new aggravated harassment charge, a new contempt of court charge, and a new violation of probation charge, each a separate misdemeanor punishable by up to a year in jail. I looked at Mom and Dad, who assured me that she didn't mean it, as I watched in horror as she began to dial. I reached for the phone. She took off running. I followed her into the bathroom, where she proceeded to lock herself in a stall and continued dialing. I forced the door open and it swung inward. I pressed the door up against her, pinning her between the wall and the door so that I could grab the phone. I hung up the call, thankfully, before it connected. She scratched and hissed at me, screaming bloody murder. Just then, her mother ran into the bathroom, crying that the court officers were coming down the hall to check out the noise. I knew I needed to get out of there. So did the client. I knew of a back stairwell, so I yanked the client by the wrist and forcibly pulled her down 5 flights of stairs. At the ground floor, she broke free and entered yet again another bathroom. This time she didn't have her phone. Her parents followed her a few minutes later, and they attempted to calm her down as I called the office to ask for advice. After all, I was a neophyte lawyer. Just as I reached the secretary, I saw 7 court officers running down the hallways with their hands on their guns. It was now or never. I needed to act. So I jumped in front of them with my arms extended, blocking their way into the bathroom. I said, "Gentlemen, may I help you?" They couldn't get around me, so they hastily explained that I needed to move, as a young woman was being accosted in the bathroom behind them. They were either going to arrest the perpetrator who was attacking her or arrest her for disorderly conduct. I gulped. Well, is it her or me? This was my moment. Lie to protect her and stay quiet, or let the client get arrested. Well, not on my watch. I wasn't going to be the kind of lawyer who endangers her client for her own interest. So I extended the phone that had my secretary on the other line and handed it to the officer, told him that it was Dr. Smith. I explained that while I was bound by attorney-client privilege from disclosing the nature of the traumatic news learned today by the client, I assured him that Dr. Smith on the other end here was about to have her admitted into the emergency psych unit at a local hospital. The officer never took the phone. He took his hand off his gun. He slowed down the other officers and agreed that if my client would leave the building immediately, they would not arrest her or me, and we would be escorted out. They did forcibly escort us out of the building. The client did end up going to a hospital, although clearly my secretary was not Dr. Smith, and no additional charges were filed against my client. I had just made my first decision to jeopardize myself in order to save a client.